just a couple of opening remarks. I hope this will be a positive experience for all who are in attendance. As the summit goes, we should kind of maintain open-mindedness with this, and just based on everything I've heard thus far, I am optimistic about today's summit. I think it should be really good. I'd like to thank the council members for attending, as well as the public and also the staff members. It is now 9:10, so we'll call this summit to order. Let's go ahead and do a roll call of the council members who are in attendance. Carmen, can you do that?
Yes, sir. William Smith. Suzanne Arnold.
Here.
Benoit Corinne.
Present.
Otis Jones Jr.
Here.
Edwin Lofton.
Here.
Johnny Scholl.
Here.
Devin Dubac.
Here.
Alex Morales. Jorge Oliveras. And Vice Chair Stephen Shane.
Here. So just a little bit of housekeeping on the hybrid meeting protocol. I ask that all council members please leave your cameras on, but you leave your microphones on mute. And as for the public, if you don't mind, keep your cameras off and also on mute until the Q&A section of this summit. And if you do have comments, anyone, I think there's a hand raise function that'll make it easier for us to call on you if you have something to say. So with that, I'll turn it over to Mr. Steve Bruno for some opening remarks and introductions.
Thank you. Good morning, everyone, and thank you so much for being here. My name is Steve Bruno. I'm Deputy Executive Director for Licensing and Regulatory Services here at TDLR. And I want to thank you all for joining us this morning. I really look forward to this discussion and an opportunity for you all in the community to understand what it is that we're looking at when we're looking at your plans and things in the IHP program. We want to continue to make sure that this is an excellent program, not only for the state of Texas, but across the nation. And again, thank you for being here and really looking forward to the discussion this morning. Please, as Vice Chair Shang mentioned, please be as open as possible. Ask us your questions. Let's get into it. Let's talk about it so that at the end of today, we all leave with a better understanding of how things work and what the expectations are. So thank you very much.
Fantastic. Thank you, Mr. Bruno. So we'll start out with a couple of presentations, but just so everyone knows, as far as the public goes, we will have 2 Q&A sections in this. So there will be plenty of opportunity to ask questions, get answers, have open discussion. So I'm looking forward to that. But we'll start with some important updates from Ms. Charlotte Melber, Director of Compliance.
Thank you very much. I have been asked to share some comments that I made at the last council meeting, and I wanted to share them with everybody here as a preface before we start the presentations. So the first is that all holds on decals and insignias have been lifted, and they are that had been placed on accounts because of the failure to have an updated compliance control manual. We have given those folks who had not yet provided the updates until March to complete those, even though they should have been done a couple of months back. But even if they're not done by March, there will not be a hold placed on them. However, we will be referring those to our enforcement division for possible action instead of placing a hold on being able to get those decals and insignias. Second, we received very fervent requests to trust the DRAs and the third-party inspectors and to not delay the process of conducting an inspection in what was being referred to as a re-review by the department of the documents. Reviews of certification documents were being done by TDLR before a scheduled inspection was happening. We have now changed that. We are sending the information to the inspector, and the inspector is going to be determining, based on their knowledge and skills, and working with the manufacturer to determine if an inspection can be completed or not. And again, TDLR will be conducting audits to determine if all the steps had actually been followed. And again, there might be a referral to the enforcement division if things are skipped, but We are going to trust the licensees to do that. And then lastly, Chrissy is going to come up and give a presentation getting into more detail on this. And we will also have our enforcement division speak on the processes. And everyone will have the opportunity to ask questions, make comments, and give suggestions. So if anybody came to this meeting with the frustration of these two items that I have already mentioned, those have been solved. They are not going to be an issue going forward. So we still want to hear from you, hear your suggestions, and hope to be able to make this program even better.
Thank you, Ms. Melder. That's a really great update. Let's go on over to Ms. Chrissy Cooper, who will now give a presentation regarding the certification document reviews.
Oh, real quickly, I just
Yeah.
wanted to announce that we do have a quorum.
We do have a quorum.
Yes, sir.
Great, great. Thank you,
Sorry,
council
Chrissy.
members.
Thank you.
It's a very, very busy holiday season. Having a
Right.
quorum is not easy, right? That's fantastic.
Should be sharing. Good morning. My name is Chris Cooper. I am the team lead for the IHB program compliance division here at TDLR. Before I start my presentation, I would like to let everyone know, if I could get my slides to forward. Carmen? Nothing is happening. There it goes. A delay.
Right.
All it took was Carmen's magic. IHB, I just wanted to announce that IHB is hiring, for anyone who is not aware. We currently have 4 positions open. We have received some applications. We'll be reviewing those over the next few days or as quickly as possible. The current position is a program specialist 4. The pay range is 63 to 64,575. But we will absolutely entertain any offers or any interest from those who are already licensed, which would be a program specialist 5 position, starting at around $78,000 per year. Moving forward. In the past, the certification process was lengthy. The IHB department would receive an approved set of documents from the design review agency. The department would review them and create what was called a pre-certification deviation report. And IHB personnel would then schedule an inspection with the manufacturer. And during that inspection, that first week we were there, and it would be a full week, we would go over that deviation report in detail and address each item, giving the manufacturer an opportunity to have documents revised that may have to happen before construction could continue, or it may have to be at the end, but that review and document revision process would continue on cyclic until all of the deviations were cleared. And at the end of the certification inspection, the documents that were approved matched the work that was done. As a result of COVID, we began using third-party inspectors more, and in fact, almost exclusively. We still did the pre-certification deviation report. We still needed to review those with the manufacturer, and that would often happen remotely. Again, a cyclic process, multiple times. We would look at the inspection reports, often include the inspector in that process to confirm what was actually conducted on site or in the factory and compare it to what the documents depicted. In the most recent past, we've been conducting a partial review, a survey of the approved documents, asking that those documents be approved and revised before the inspection was scheduled. And that was intended to happen as many times as necessary, but obviously that didn't go so well. So we are now doing a partial review and at the same time asking that the inspection be scheduled with a third-party inspector. The third-party inspector will have to make the decision of whether the documents contain sufficient information for a certification inspection to be conducted. And those documents will have to be obviously revised and approved before the certification is complete. Our intent in the future is to have documents approved by the design review agency without the department having to review them. Have the inspection scheduled with a third-party inspector, and IHB's role would be limited to audits. I do want to bring up the design review agency survey, the DRA survey. All of the items on the survey are based on deviations that were cited in those pre-certification deviation reports and items that the program specialist deemed to affect life safety. When we look at those pre-certification deviation reports and we look back at the statistics of it, we looked at the last 101 instead of 100 because we had 2 reports on the same day and couldn't determine which was the oldest. In those 101 reports, we identified or found that there were over 4,000 deviations cited, with the average number of deviations per report as 42. Median 37. And we did have one report that had 0 deviations, and we did have one report that had 146 deviations, both outliers and anomalies. But you can see the distribution of those deviations, where most of the deviations, almost half, fall between 25 and 49. But the majority of deviations fall within that range of 1 to 75. These are the top 10 deviations that were cited with the count. And in essence, that's going to be a percentage, right? The 21, which is the total of those top 10, account for over 64% of the deviations cited in those reports. So those design review or that design review agency survey, the first portion of it was based on what was required by the DRA guide procedures. On page 7, there's a very clear mandate that the DRA provide the data plate compliance control manual checklist. And on page 13, I've got a delay in exceeding the requirement for the transmittal sheet. This transmittal sheet is important for the department because it helps us sort those documents, know whether they're commercial, whether they're residential, who the manufacturer is, the plan review. It's a key component. On the plan's cover page, we require the building parameters. Again, one of the top 10 deviations cited in the pre-certification deviation report. These are items that are critical to the local building official and information about the building. We required information about the material and how the building material is installed. And the energy code, the number 1 item on the pre-certification deviation report. And then that takes us to the compliance control manual, a section that's open on the survey report because there are so many things that appear to be wrong, because that accounts for half of the top 10 deviations that are cited on the pre-certification deviation report. So the survey was not produced willy-nilly. It was all based on the past and our experiences with those documents. In those surveys, just the initial surveys that we did from June until we quit doing them in mid-November, we only issued 21 surveys. We found 192 deviations with an average number of deviations cited at 5.8. So in fact, the program specialist, even though they were allowed to stop after identifying 5, they continued on and found more. There has been a note that they appear to be administrative deviations, and that may be because of the cover page. It was often very easy to find 5 deviations on the initial cover page that contains information about those buildings that's so critical for the local building official. These are the top 10 major deviations and the minor deviations. I'll make this information available to anyone who would like a copy. I do want to address also myth and fact. Things feel different now. Well, that's because things are different now. There are different processes and different expectations as we transfer that responsibility from the department onto the design review agencies and the third-party inspection agencies. Myth is that IHB is reviewing more and it's causing delay, and I'll address this in two parts. First, IHB is not reviewing more. IHB is actually reviewing less. We're no longer conducting that full pre-certification deviation report, and we're only conducting the survey. Currently, IHB is immediately requesting that the third-party inspector evaluate the documents and schedule the inspection as soon as they can. We do not want any inspector to conduct an inspection if they do not believe that there is sufficient information to determine compliance. Myth versus fact. IHB is reviewing all of the plans. IHB has not been reviewing all of the plans that we've received. We've only been reviewing the certification documents. We will not be reviewing all of the plans in the future. There's just too many. We literally do not have enough hours in the day. We receive hundreds of sets of plans per month. But we will be reviewing all types of plans and manuals. That will come from a percentage of all the plans and manuals that are randomly selected for audits. Those projects that are identified as high risk. And any documents associated with consumer complaints. Moving forward, we need everyone to do things right from the beginning because we don't have time to fix it. Until further notice, IHB will still need the certification inspection request from the manufacturers. We will request and schedule those plant inspections with the third-party inspection agencies, and we will conduct entrance meetings with the manufacturer and will review the laws, rule, and procedures with the manufacturer. It's commonly called a red book review. If you need assistance determining what those deviations are, things that we will be looking for when we are auditing, I would encourage you to look at Chapter 70, the rules, and in particular Chapter 7070, which details the responsibilities of the manufacturers and the design review agencies and the third-party inspectors, and the things that need to be in the documents. Look at the data plate requirements and the compliance control manual checklist. Look at the codes and the code amendments. That's 7100 and 7101. Look at the pre-certification deviation reports that you've received in the past from us. I'll be glad to provide you with a blank document that enumerates the different areas. Look at the survey reports. Look at the inspection reports and feedback from the third-party inspectors. And obviously, IHB is always available if you have questions. And I believe we are ready for a poll and a question and answer session.
Thank you, Ms. Cooper. That was very thorough, very comprehensive presentation. Appreciate the myths and the facts as well. So now we're going to do the poll everywhere, and Tamala Fletcher is going to be operating that.
The poll has been activated, and I am sharing my screen.
So just so I'm clear, we're going to do a poll first and then just have general questions and answers. Is that correct?
Yes.
Yes. Okay. Fantastic. All right. So you can see the poll on Ms. Fletcher's screen. Okay. So please share any comments or questions about the certification or review presentation. So if you have any comments on that or questions, go ahead and use the poll anywhere. And I believe to do that, do we have to, does the audience need to scan that QR code in the upper right?
Yes, they can scan the QR code or they can join by sending a text to TDL 22333, indicating TDLR, and it'll give them the proper questions.
They can also go to the website that's listed there. It is fullev.com/TDLR, and they should be able to log in there. And so what this is for, this is if you want to make an anonymous statement or comment or question, you can type it here and we will see that. If you have questions or comments, you can absolutely raise your hand, and you will be called on and we can have a discussion. So this is just an opportunity to ask any questions about this first half of the summit, or processes and procedures.
Sorry, that was me. I was just testing.
Yes, I am well, thank you.
These responses are coming in.
All right, so the first question we have, highly encouraged to hear the operational shift toward audit-based oversight. Does the department plan to extend this model to initial plant certifications, ICC 1205, to help clear the factory onboarding backlog?
We absolutely do. That is the plan.
Fantastic. How are major versus minor deviations determined?
That's based on the codes, the building codes and the requirements laid out in the rules,
And how do you determine which is major and which is minor?
which would be a life safety issue.
So if it's a life safety issue, it's termed major. If it's not, it's considered minor.
Got it.
And those are all listed
Yes.
in the.
I will add the caveat of, let's say, for instance, the engineering license requirement. That information that's required by the Texas Board of Engineers and Land Surveyors. And that is the assurance that the work that's done is done by a licensed professional.
Perfect.
And so this next question about the high risk during Chrissy's presentation of the 3 different categories that we will be using to determine who gets audited. That is something that's going to be work group related. We are
Yes.
going to have a conversation and come up with that, and determine what that will be.
May I ask a question as well, or do I have to type it in the poll anywhere?
You can ask a question, absolutely.
So on these last 2 questions around major and minor deviations, as well as the high risk, as a council member, and I open this up to my colleagues on the council, I believe section 70.61 talks about how the design, the monitoring and the inspections of the plants are in accordance with procedures set by the council. And so I just want to understand what are our responsibilities, or what is our contribution to major and minor deviations, as well as what are high risk projects, to make sure that we're doing our job as council members.
I would respond that when you adopted the in the rules 7100, when you adopted the rules that set out the codes and the amendments, that you laid out what you anticipated that we would do, and that would be to assure compliance with those specific rules that you adopted.
And I will also chime in and add that on the major and minor, that was a 6-month project that we instituted just to determine what to send back and what to allow to proceed. But that is no longer an issue because we're sending everything to the inspector. So the major and minor is no longer
Okay,
something that is holding anything up.
gotcha. So this major and minor deviation, the big M, little m's, that's not relevant now that we've streamlined the process based on what Ms. Cooper
It was
presented.
always intended to be until January the 1st. I mean, we sent out a notice when we began that process.
Yeah.
And made everyone aware that this was the transition. And those were there to help help the design review agencies identify those issues that we were finding repeatedly.
And so we can review the examples of major and minor, but again, it's no longer relevant to our processes and procedures. We were just explaining how it was working during that time period, and as a data gathering exercise.
Gotcha. But just to be clear, the rules themselves don't specify what's major, what's minor.
That is correct.
That was something that the staff determined.
If you were going by the building codes, they would all be major, right? Because the building code lays out very explicit things. And so we opted for identifying some that might be less critical to the project moving forward.
And just in case anybody doesn't understand what we're talking about, listening online, I kind of want to preface this. In Chrissy's presentation, she mentioned that every single pre-certification inspection, all of the documents were reviewed 100% by TDLR staff. And those documents, if there was anything that we determined were not accurate or not included, or, didn't
Unclear.
meet the requirements, unclear, we would send it back and we would go back and forth for a long period of time, up to several weeks, until they met our standards of what we considered following the law, the statute and rules. And then we would send it to an inspector to conduct that inspection. What we're saying, what we did was we didn't have the time any longer to be finding all of the errors that we were seeing in these documents. So we put everyone on notice that, hey, in 6 months, we're not going to be doing this any longer. You're going to have to get it right at the beginning or find your own errors. But so that people would understand what we had been sending it back for, we did this 6-month major and minor thing to just tell them, hey, this is what we're seeing. You're not getting these things and you need to start getting these things because in January, we're going to start sending you to enforcement. We're not going to keep going back and forth because we need to streamline this process. Based on the feedback that we were getting, we decided to streamline it now. And it's now just going to the inspector. And the difference is a case may be opened in enforcement, and the next presentation is going to be our enforcement chief prosecutor to explain how that process works. We were trying to get everyone in compliance. We didn't want there to be penalties or violations, and we wanted everything to be working smoothly without that in the process. We simply don't have the manpower to do that any longer, and so we are having to rely on the DRAs and the third-party inspectors to make sure everything is done accurately. And if we do an audit of a project and we find out that it was not, we will be referring them to the enforcement division for not having followed the laws and rules. So just to be perfectly clear as much as possible, the major and minor deviations, there is nothing, no weight to them at all. It was just a process that we put in place to try to put people on notice of what we were seeing and what will be a problem in the future if it's not going to be correct.
So if it's okay, I don't know if this is too much tech or anything like that, but I think it might be helpful, just so we learn from history, to go ahead and put up a copy of the preliminary survey of documents, just so the public who's participating can see the big M's and the little M's. Is that something we can pull up on the screen? Yes.
I can try. I would
Okay.
have to stop
So
sharing the
while
poll.
we're doing that, I'll just give a couple
Yeah.
examples and then add a follow-on.
She would have to
question.
stop sharing the poll.
Okay, so let's stop sharing the poll real quick and pull that up, if that's all right. And then we'll go back to the
And then
poll.
we'll come back to that comment.
Carmen, you
okay.
have-
So for example, while they're pulling that up, like, I have it pulled up on my computer, like one example of a major deviation that I'm seeing on this preliminary survey of documents is the structural load calculations are provided. Another major one would be the Texas licensed engineering seal. And that's compared with a minor in the same category, that is the name and registration number of firm on each sealed document. And another minor one would be engineer and firm registration is current. So that would be, in case you can't see your screen, a couple of examples of kind of the 4-page document for these majors and minors.
Give us 1 second. Let's ask everybody to hold on 1 second. So we
Yeah.
get this pulled up.
There we go.
Awesome.
Let me zoom in a little bit, see if we can make it a little bit more legible. Can everyone see that?
Can y'all see that okay?
Yes.
Yes.
Great, thanks.
Okay, so here you can see an example of the majors and the minors. In the third column, capital M means that it is major, lowercase m means it's minor. Is that correct, Ms. Cooper?
That's correct. And at the bottom, you'll notice there's a footnote that indicates that it takes 4 minor deviations to equate to 5, or 1 major deviation. And that was purely about when we would send that document back.
Perfect.
And again, it holds no legal weight. It was just a process that we put in place to put people on notice of what we're checking.
So, just to be clear on the no legal weight, and this might be part of the enforcement conversation.
Mhm.
But I just want to be clear, is this going to be, when we start doing audits and only audits, right? Is this kind of big M, little m protocol going to
No.
be inherited by enforcement, or is enforcement just going to see?
We're not
there were
even using this
deviations?
anymore internally at all.
Okay, so,
We're not
okay,
using it,
so council won't see like, oh, this DRA missed 5 major deviations and 2 minor
No.
deviations.
That's correct. We're not gonna, this was just a previous process. We
Gotcha,
are no longer using it.
okay.
A transition process.
Yes.
Gotcha. And just so we learn from history, would this have been something that the council would need to have input on in the future if something like this were to come up as far as major and minor, or is this something just from an authority standpoint
And
that,
it's not even an authority situation. So no, it wouldn't have been. This is an internal procedure
internal
of
procedure?
reviewing. So it's, if it had legal weight,
Uh-huh.
if it was going to be referred to enforcement based on these things, absolutely the council would be involved.
Gotcha,
This was just a notice that we were sending to the industry.
gotcha. I hope that helps clarify some of the questions. Ms. Cooper, we can just scroll through the rest of that so people can get an idea of what was on this list, and then we can flip back over to the comments and then
Okay.
pull anywhere.
So, engineering calculations was a section, obviously critical to the safety of a building. Each of these items are in the building area are specified in the rules that have to be included in the documents. The steel design, obviously, straight out of the International Building Code. Energy code. And in the rules. The mechanical information, again, in the rules and in the building code. The same for plumbing. Same for electrical. Engineering trusses and beams and other engineered products. Accessibility. Membrane roof system. This is always an issue that comes up when there's a TPO roof. So it made sense to include it. Obviously, fire rated construction and listing reports. Egress and safe exit from a building. Details for stairs, again, a safety and egress issue. Sprinklers and fire systems. Required documentation from the fire marshal. And minimum requirements for things that are required on site so that the engineer designing the foundation has basic information about, for instance, how much the building weighs and how the building is attached to that foundation, or how the modules go together. And then a section that allows us to move with compliance control. Did you need to see anything else?
I think that's good for the public so that they know what was on this list of major and minor. If we can flip back over to the poll, we can see if there are any additional questions on that. But again, to Ms. Melder's comment, this is not relevant anymore. We're doing this as of now, so.
That's correct.
Yeah.
And there was a statement on there that I'm sure will be shown in just a moment, saying that it was harder on the DRAs and the manufacturers when we only told them 5 of them rather than doing the full review. And we understand that. And it was intended to be a transition period to say, we're gonna stop doing it altogether. So you're gonna need to find these things on your own. So they should have all been done originally, completely. And so we tried to put this in place in order to try to transition people into knowing that we're gonna stop looking for all the errors on the front end. They're gonna need to do it themselves.
Yeah.
So yes, it was more work on their end. And it's unfortunate, but we have stopped this and we are just moving forward, and hopefully everybody will include everything that's needed when they send them in.
So yeah, just to be clear, what Ms. Melder is addressing is this current comment. The 5 deviation threshold has introduced unintended inefficiencies. Returning plans after identifying only 5 items without issuing a complete list of findings has created multiple review cycles for some applicants. This is an eye test today.
Would you like for me to read it?
I'm sorry.
Yes, if you don't mind.
I don't
just
mind
'cause
at all.
We have some people
The 5
participating by phone.
deviation threshold has introduced unintended inefficiencies, returning plans after identifying only 5 items without issuing a complete list of findings has created multiple review cycles for some applicants. We understand the desire for consistency in review outcomes, and a collaborative discussion of deviation criteria and procedures would help clarify the process for both reviewers and DRAs. Again, we're not doing this process any longer, so hopefully it's not an issue. The statute and rules and codes set out what needs to be included before a DRA should be stamping that as approved. And so we have provided documents and they're on our website, and you can message Chrissy for her presentation, etc. So you will see what is required by law in a different format than just the actual statute and rules. Okay, the next one. Recent plan re-review practices represent a notable shift from prior program operations. Texas has historically relied on DRAs to provide code-compliant plan reviews because the statute permits it and because DRAs have the necessary engineering and technical resources. Under 7061A, the department's responsibility is to monitor DRA performance. The expanded practice of re-reviewing DRA-approved plans appears to go beyond monitoring and has resulted in prolonged review cycles for many manufacturers. Greater clarification on the intent and authority behind, you scroll up a little bit because there's a tab in front of that. Okay, behind this shift would help all parties align with program expectations. As explained by Chrissy's presentation, we've always done this in the 17 years I've been at TDLR. There is no new re-review happening. Every single document has been reviewed and sent back and forth
For the
since
certification.
for certification of documents. The only thing that changed was we stopped doing a full review and we only did a partial review due to staffing and time and the intent to rely on the DRAs to find these issues. And so there is no re-review. There never has been. This is something that has always been in place. We actually pulled back, and the pullback of doing less review has created the difference that everybody is seeing. But again, it's no longer an issue because we are not doing that either. We are just going to allow the process to proceed. And if there are violations, it will be transferred to our enforcement division.
And Ms. Belder, if I
Yes.
may,
Yes.
just provide a little context. So I'm sensing there is, and maybe whoever's making these comments, please let me know this is clear. But what's going on, I think, is there are 2 types of plan reviews historically in the 17 years that you've been,
Yes.
and even longer. One type is just the basic plan review.
Mhm.
The other one is a certification plan review.
Yes.
And so what we're saying here is, as far as the basic plan review goes, where you're already certified as a factory and all that, TDLR has historically just spot checked and done audits and all that, and that's been traditional. Now, about 6 months ago, we had a rule change where we said, okay, for certification reviews, that's not going to be up to the state to do 100% plan review. In fact, if anything, we're going to let the DRA start doing that. Right.
There was no rule change.
It wasn't a rule change,
No.
Robert? Okay, sorry. I thought we gave authority to the DRAs to do the initial certification. Is that not right?
No, that Robert Reyes, Assistant General Counsel, that was a rule change for
To allow third-party
Third party,
inspectors
yes.
to be a team lead in the inspection.
To be a team lead in
Yes.
the inspection. And so now we're talking about that set of plans,
That's a different
and that's
issue, the
because of the
inspection.
certification. Is that right?
I'm sorry?
Is it because of that change that we
No.
did that's causing this?
No.
Oh, it's not.
No,
Okay,
it's
I'm sorry.
completely
Then I'm
unrelated.
It's
confused.
the inspection process is a different process than the plan review process.
Gotcha.
A manufacturer doesn't even have to use the same design review agency as third-party inspection agency.
Okay,
So it's a completely separate entity and a completely separate registration to do plan reviews and to do
Right.
inspections. It's a different process.
so then maybe the public can chime in on this. I'm confused too then on this
So-
comment around the notable shift. What?
The notable shift, as Charlotte explained, in the past, IHB program people would do a full review of the certification documents and write up a pre-certification deviation report that might have as many as 146 deviations that were found and not noted by the design review agency when they submitted the plans.
Right.
So these were approved plans. We conducted a review of them and went over these with the manufacturer during the IHB conducting the certification inspection and as part of that inspection process. The only thing that changed was that we quit doing that full review of the documents and providing that to the design review agents. We began just saying, I found 5, you need to look at them again.
So we were relying more on the DRA, which is what everybody had been asking for, to find these on their own. And it is so disruptive because I believe the agency had, or the program had become reliant on TDLR finding any issues. And we stopped doing that. And so it was disruptive because they now had to fully look at these and we weren't going to find them for them. And so to answer this question, how do we avoid future transitional actions that become so disruptive?
Right.
The whole plan is to get to a point where our actions do not disrupt the industry. And so this next move of, okay, we're now, which has already happened, we're now not doing the initial review at all. No deviations, no anything. We're sending it to the inspector. We are relying on our licensees, the DRAs and the third-party inspectors to follow the statute and rules and codes. And we are just going to audit. And if we see anything in the future, it will be referred to our enforcement division. So we are stepping out of this process. So to make sure that these transitional things are not disruptive in the future, it's already happened.
Gotcha.
It shouldn't happen in the future because we simply don't have the staff or the time, and we need to rely on our licensees to be able to do this properly.
Yeah. Okay. I hope that's clearer to those who are in the public.
Okay, so Christy, this next question, if you can answer. We are not talking about certification review.
We are talking about.
No, I understand. Everything we did was only related to certification review, but the people making comments are saying their comments are not related to
So
certification.
and they're talking about daily plan review.
Daily plan review and
We have
third,
not had the manpower to conduct a review of those.
we have never done a daily plan review.
Exactly.
In fact, we haven't even been doing audits. I nodded when you said it before, but I was like, we haven't even done those.
Because we haven't had the manpower.
But we are going to start doing those for the daily plan, the things that are coming in the 200 a month. We're going to start doing the audits on those. And the third party QC manual review. What is that?
That's the same, it's part of the certification documents. And so when we are performing those audits, we will also be looking at the compliance control manual that the manufacturer is supposed to be using for every unit produced.
Which is part of the certification review. So that is
And it would be
Related.
part of the
the
audit
audits.
that occurs. To look at that document and make sure that it accurately reflects the processes that the manufacturer uses on a day-to-day basis.
I hope that addresses that comment. So I think what I'm sensing just from these comments from industry is just, I think it's great that we've shifted away from this. I think it is just the fear that this might happen again, right? In some way, in some strange form that we don't expect today. And are there steps that we can take as council, as a department, put safeguards in place to make sure that this won't happen again? Because it was highly disruptive to industry.
I think communication is key. We are going to have a much more open discussion and dialogue. And to make sure that anything that we do will run by the chair. And he can determine how he wants to proceed. Well, as a courtesy. And we'll make sure we just keep that open. The next question, why would you send it to enforcement if you are a monitoring agency? Now, I'm not sure what you mean by monitoring agency. We are the agency who is responsible for making sure that everything is done accurately. And the law says things must be done a certain way. And if they are not done that way, it is a violation of the law. And when we get to that point, our enforcement division will explain what that means. So it's referred to enforcement because that's what our agency has been charged with doing, is making sure the law is followed for this program. Okay, another one just popped up. Some recent procedural changes may reflect staff interpretations that have not yet been thoroughly reviewed. To ensure accuracy and consistency, specific procedural adjustments have been implemented at the staff level without complete council evaluation or through the formal rulemaking process. A review of these practices would help clarify their basis, ensure alignment with council expectations, and support consistent application across the program. Again, we're not doing it any longer, so staff's interpretations are no longer relevant. It will go through the enforcement process, and again, John is going to be talking about what that enforcement process is and explaining that there is no staff interpretation. It will come down to the law and rules, and it will go, if it's contested, it will go in front of a SOA judge who will determine the correct interpretation.
In front of a what judge? I'm
A
sorry.
SOA, State Office of Administrative Hearings.
Gotcha. So there is a check and balance to this.
There is a checks and balance, yes.
Okay. And I think we talked about this in our last council meeting when Scott was presiding. But to have complete council evaluation, I think if we have more regular meetings than we've had, that would be helpful to ensure that this communication that you're talking about, Ms. Melder, happens.
Does anybody want to unmute and actually talk? Or ask a question or make a comment before we move on to the next step?
I think we're okay. Any comments? Other comments? Okay, I think that was a very thorough, lively discussion. I'm encouraged to hear that we have moved on off of that position and we've changed things. So thank you for getting in front of that. Am I allowed to call like a quick bio break? Is that okay? Okay, so why don't we take a quick 2-3 minute break so people who are participating remotely don't get Zoom fatigue. And we will take, we'll be right back for the next section where Mr. Medlock will present on the enforcement process going forward. There we are. All right, looks like we have the council members back. Thank you all. It is 10:04. We are back from our break. Next up on our agenda, we have Mr. John Medlock, Chief Prosecutor, to talk about the enforcement process. And again, after his presentation, we will have Q&A with the login to Poll Anywhere. Thank you all so much for your participation in the earlier poll. That was fantastic. Mr. Medlock.
Thank you. Good morning, everyone. Again, my name is, excuse me, John Medlock. I'm the Chief Prosecutor here at TTLR. I have been in this role for a little over 5 years, almost 6 years. Been with the agency for over 13 years. I'm going to try to share, they're trying to give me access real quick to share this PowerPoint that I have for you guys. But again, a little bit about it. I actually did work these cases for about 7 years while I was kind of a frontline prosecutor, so I am very familiar with the IHB program. Okay, Carmen may have to share it for me if I can't share it. Apologize for the technical delays. Oh, there we go. I've got it. Okay. Does everyone see this PowerPoint?
Yes.
Yes.
Okay, perfect. Okay, again, so what we'll do today is we'll just kind of go over an overview of the enforcement process. A few of the things, kind of some more contextual and background information, so you kind of know a little bit about what the enforcement division looks like and how we're kind of structured, but then also we'll kind of get into some more nitty-gritty details behind the process. As you can see here, TDLR, we are functionally aligned. On the licensing and regulatory services side of the house, as we're calling it, we have 6 different kind of big divisions led by our Deputy Executive Director, Steve Bruno, customer service, licensing, education examination, field inspections, compliance, and then we're over here on the one side, the enforcement side. So that's, at least on the TDLR side, how we kind of handle things. Everything in compliance goes through Charlotte, her side. Everything in enforcement goes through my boss, Ron Foster, the enforcement director. In terms of the just the enforcement division, we are one of the largest divisions within the agency, and we are also functionally aligned. We have 3 different sections within the enforcement division. We have an intake section where all the cases come into in our process. Cases that need investigations go through our investigation section. And then over on the prosecution side of things, we actually have 2 different managers, myself and Cheryl Wilson. Right now we have a team of 20 attorneys and I believe 34 legal assistants, but 44 total staff over on the legal assistant side of things. And so the reason that we're split up in this way is because that's kind of how the case naturally flows, right? Cases come in, we got to process them, organize them, send them to the different correct groupings in terms of all the different programs that we regulate. We've got investigations. We have some field investigators. We have investigators here in Austin. And then again, same thing with the prosecutors and legal assistants. We're kind of a team, even though we do have 2 different managers, and we handle all the cases. Just kind of a big overview. We now have 42 programs. The way that we kind of do it in the enforcement division is we kind of group like programs together. And some of the kind of the names we have is we refer to them as building and mechanical. That is our air conditioning, our electricians, elevators, escalators. IHB fits into here because it's a building and mechanical type program. We have beauty and wellness type programs, which are your cosmetology, barbering, massage therapy. Transportation would be all things moving, our tow trucks, our vehicle storage facilities, the motor fuel metering and quality program, which is all the fuel pumps in the state of Texas. We have health-related programs such as podiatry, speech language pathology, and audiology. We have a group of attorneys that handle all of inspections because a lot of our programs do have inspection components built into it that are handled by our different division, our field inspections division. We have what we call consumer and financial services. That's some of your property tax professionals, property tax consultants, your service contract providers, that kind of fits in there. And then ultimately, every licensee, which we have a little bit over 1 million licensees in total, get a criminal history review. I won't go into too much detail about the criminal history process, but just know that every time that you apply for a license, as if it's a brand new license or go for a renewal application, a criminal history background check is run. Some of our programs, such as massage therapy, speech language pathology, do additional fingerprint background checks. So in addition to the Department of Public Safety background check, we also do an FBI background check on those folks. And each program has what we call a unique set of criminal conviction guidelines. Those guidelines kind of help us determine if we don't think that someone should be in the industry. Each program, like I said, is unique. Some of these building and mechanicals are going to consider crimes like theft, burglary, those kinds of crimes as being kind of not necessarily prohibitive, but they might look disfavorably towards licensing. Again, in terms of licensees, over 785,000 individual licensees with over 200 license types and almost 300,000 inspections performed. We also do have a subset of business licenses that puts us over the top, over 1 million licensees. Just what we did last year in terms of prosecution, just to let you know how much volume that we churned through. Nearly 13,000 cases were opened, and almost that many were closed last year, with a little over 1,600 orders signed, assessing nearly $5 million in penalties, nearly collecting $2 million. But the thing that I'm most proud of for our section is we collected nearly over $800,000 in consumer restitution. So that was money that went back into citizens of the state of Texas pockets versus going back into the general revenue fund. So now, kind of, I think what everyone's kind of interested in is how do we review cases here at TDLR? And I'm really going to speak mainly to the complaint-based cases because that's kind of what the focus is for your program, because we're more of a complaint-based type recipient of the of these types of program cases. So essentially what happens is the consumer files a complaint with the department, and those can be online, they can be fax, mail, occasionally a phone call, but the vast majority now come through the online. Now, like I said, our intake section, they handle all the cases that come through. Their job basically is to determine kind of jurisdiction type questions. One of the questions they ask is this a program that we regulate? Because, like I said, we have 42 programs that we regulate here at TDLR. We still get cases for plumbing. We still occasionally get engineering type cases, but we have to refer those out to those people and those boards. Occasionally some medical board type cases, because we do regulate podiatrists, which is a medical field, but we don't regulate doctors. So that's kind of the first question they ask. If the answer to that is yes, then obviously they're going to move to the next step. The next question that they'll ask is what is being complained of something that we can do something about potentially? And what I mean by that is, in the easiest context I can say it is, in the world of air conditioning, if your neighbor had an air conditioning system put in and it cost them $10,000, 2 weeks later, you get the exact same air conditioning system. Your house is the exact same. Everything about everything is the exact same, but it costs you $12,000 and nothing is different. Well, they might file a complaint with us. One of the things that we don't regulate in that program is price. And because we don't regulate price, we're not going to open up that case and take any action on that case. However, if same thing, but the AC system does not work, then it's a mechanical integrity issue, and that is something that we can do something about. So the intake, like I said, they review those cases for jurisdiction, that basic jurisdiction type question, and then if those two questions are satisfied, then they will move it over to our investigator. Now, our investigators do kind of what you would think that an investigator would do. They ask the who, what, when, where, how, why questions. They will talk to obviously the person who complained. They will talk to the person who is being reported against or the respondent. They will try to gather facts, evidence. Sometimes it can be, excuse me, tangible evidence such as photographs or even like equipment. Most of the times it's just statements or witness statements that might lead to other witnesses that they need to talk to. Occasionally with some of our programs, we do need expert reviews. This would be one of the programs that we would consider looking for an expert review, and we would get with the folks, Chrissy and her staff over in compliance, to get some of those expert reports to us. They will, our investigators are good at asking the who, what, when, where, how, why questions, but they're not subject matter experts like the folks in compliance are. That's why we have those folks on staff. So if there's ever code questions or issues such as that, we will go to those folks and ask them, and they will draft us an expert report for us to use in evaluation of our cases. The investigators will also draft an investigative report of what they find. They're not there to presume what they think happened. They're just there to collect the facts and collect those statements and the evidence, draft that in the report. They will collect that expert report if needed, and then we'll move the case over to the prosecutor. Now, the prosecutor's job is to review that case and to determine what the outcome of that case is. 99% of all the cases that come through the enforcement process end up with a decision made by a prosecutor. Currently, for your program, we now have 3 prosecutors assigned to handling building and mechanical type cases. So one of the 3 of those prosecutors, it's either Stuart Baggish, Leslie Nichols, or Andrew Lisenby will be handling one of those types of cases for you guys. So like I said, the cases come through the enforcement division and to the prosecutor. We have essentially 3 types of things that we can do. We have closings, warnings, and what we call NOAVs, or notice of alleged violations. So what does that look like? So a closing letter is usually because we determined that there's not legal sufficiency to move forward with the case. There might have been enough to open the case on the front end, but through the course of the investigation and our review at the prosecutor level, we just determined there wasn't legal sufficiency to move that case forward. It could be a situation where by the time it gets to us or during the course of us reviewing that case, some sort of correction was made or restitution has been handled and taken care of. And in that case, we will end up closing that case as being informally resolved. Occasionally, we do get complainants that decide that they don't want to move forward with the case, and they ask to have the case withdrawn. So that could be another reason we might close the case. The next kind of thing we do is we might issue a warning letter. It may be a situation where there was a violation, but again, some corrections or modifications have been made, and we decide that instead of closing it, because maybe there wasn't any restitution, or maybe there couldn't have been restitution made, we might want to issue that warning letter. And also, these are usually for typically lesser type violations. And I'll get into that, what I mean by lesser type violations here in a minute. Also, important to note that a warning letter is not a disciplinary action. So it is not something that will go on your formal record. It is not something we typically consider in terms of if you have an enforcement history with the department. It's not going to be posted on our website or anything like that. So it's not a formal disciplinary action. And then lastly, we can issue what we call a notice of alleged violations. That's when we're looking to our enforcement plan to determine the possible administrative penalty or sanction. And there's also a possibility of requesting an injunction through the Attorney General's office. And again, I will kind of get into that here second. Closing and warnings are pretty easy. Like I said, they're less severe. Definitely, there are no disciplinary actions. But in the event that we decide to issue a notice of alleged violation, that's when we have determined that the evidence is sufficient to support an allegation, that there's either been a program rule or statute that has been violated, and we want to move forward with that violation letter. Now, what does it mean that the evidence is sufficient? So if you think on a continuum, like from 0 to 100, in the criminal context, you have to convict someone beyond all reasonable doubt. That's like 99.9999%. What we're dealing with, which is much less in terms of a burden of proof, it's more like 50.1 or 51%. It's what we call a preponderance of the evidence. So it's more likely than not that what we're alleging to have occurred did occur, and that we have the evidence to support that. So that's the standard that we use in terms of our burden of proof that we have to go forth with. So if we have that met, that's when we're going to issue this notice of alleged violation. Again, it can range from anything from an administrative penalty to an administrative sanction or both. And how we come up with that is we use the department's enforcement plan. Again, just like the criminal conviction guidelines that are unique for each program, each program has their own unique enforcement plan with a penalty matrix. Now, the penalty matrix, basically what it is we take all the statutes and rules and we break them down and we put them into different classifications of and we also have like subject heading to kind of like or group like program or like violations together. So you might see Class A all the way to Class D, with Class A being the least severe type of violation, probably a very minimal penalty in terms of like a range of penalties. Class D being the most severe, where you're usually going to have a higher penalty or the highest penalty and probably the most severe sanction. Now, what type of violations can we have? Our Chapter 51 authority, which governs all of TDLR programs, sets it at $5,000 per day per violation. Now, in the penalty matrix, we don't actually do that. We cap ourselves at $5,000 per violation, and that's usually at the Class D. Class A usually maybe being up to $1,000. Class B usually being somewhere between $1,000 to $3,000 and the possibility of a sanction. Class C usually being somewhere between $2,000 and $3,000, or sorry, $5,000 and some sort of sanction, and Class D being usually your $5,000 and some sort of a sanction as well. We develop these penalty matrix with the help of the different advisory boards and councils, such as y'all's. Usually what happens is on the very front end, if it's a new program, the department will try to take our best guess at what we think these groupings and these classifications should look like. And then we'll go to a work group of that advisory board or council to say, hey, this is what we're thinking. We need to get you guys' input because you guys are the experts in the industry. And then we will then take that to the full advisory board or council for adoption or for approval. And then ultimately our commission, the Commission on Licensing and Regulation, will adopt that for our use. And really what it is we break it down and we put it in plain language so that people know what it is that there could be cited for and what kind of range of penalties or sanctions that they might be looking at. We don't just, when we put it in this penalty matrix, we don't just put the verbatim what the statute and rule says. We put it in a plain talk so for people can kind of understand it with the citation, so people can go look to see what the exact citation is as well. We also, again, don't do the $5,000 per day per violation because we want to try to be as consistent as we can across the application of these violations. Like I said, we have 3 prosecutors that work this program, so we want to make sure that just because it goes to one prosecutor doesn't mean you're going to get a heavy-handed version of a violation versus somebody else. We want to make sure we have equal application across the program, across the prosecutors. That's another reason why we have this penalty matrix. Now, again, I'll go into this in a second, but once we issue the NOAV, essentially 3 types of orders could happen as a result of that: agreed, default, or commission orders. Agreed orders are kind of what you think they were, is the parties have essentially come into agreement on whatever the penalty or sanction could be, and we reduce that to writing and have it signed off by our executive staff as an agreed order. Of note, all of our notice of alleged violations are discounted at 75% of the full penalty amount, and that's just to encourage settlements. So if you've ever seen one of these, or if you've ever received one of these, just for an example, if it was a full, you'll see 2 amounts on there. You'll see the full penalty amount of $1,000, but hey, we'll settle this for $750, which is 75%. On the back page, you'll actually see a settlement agreement on that back page for that full 75% amount. So there are occasions where we send these notice of alleged violations out, and the next correspondence that we hear from the respondent is a signed settlement agreement with a check or a electronic payment made to the department. It is also a note that the prosecutors do have discretion to reduce these penalty amounts to 50%. Again, it's to encourage settlement on these cases. So depending on how people handle this or how the respondents comes to this, just know that the prosecutor does have that discretion to reduce this by a little bit more if they want to. Now, a default order happens when essentially we don't receive correspondence or any kind of heads up from the respondent. We'll issue that notice of alleged violation. You'll see a time frame on there in which to respond. That time frame is the due process rights that we have to give people before we can, as a department, take action against somebody. So once that time period runs out, we send out a secondary notice called a notice of default that gives them an additional time to respond. And if after that period of time responds, if we have not heard any correspondence back for the person, we will get our executive to sign off on this default order. Now, of note, the default order, after when it's signed, it's not signed for the 75% amount, it's signed for the full amount. So whatever the full penalty amount was, or even the full sanction amount was, that is what the default order will be signed for. So, but it's also important to note that just because you get a notice of default, and that may be the first time you saw this or whatever happened, please get in contact with the department, because we can still go back and work out an agreement at either the 75 or 50% reduction and get to that agreed order stage. So we're not going to turn anyone down just because it looks like time is running out. We're going to make sure that we try to get to those agreed orders. And then lastly, we have what we call the commission orders. So in the event that a notice of alleged violation goes out and the person reviews it and is like, you know what, I'm going to fight this, that is absolutely their right. They will send in a request to us to have a hearing before the State Office of Administrative Hearings, or what we call SOA. Those usually get docketed out probably at least 3 months out, if not a little bit longer, because SOA doesn't just handle our cases, they handle all administrative agency cases in the state of Texas. But we will get assigned an ALJ, or what we call an administrative law judge, and we have a trial. We have opening statements, we have closing statements, we put on witnesses, we introduce evidence, cross-examine witnesses, all the things that you would think of as a trial. Couple of exceptions is, one, Now all these are via Zoom, which makes it easier for parties to attend and witnesses to attend. It used to always be down at the State Office Administrative Hearing Building here in Austin. So that's made it a little bit easier. Also, there is no right to a jury at SOA, so it's always before the administrative law judge. And at the close of the hearing, or at the end of closing arguments, the ALJ does not rule at that point in time. They have about 60 days to determine what they think should happen with the case, and they don't say this is what the order is. They basically write what we call a PFD, or a proposal for decisions. And basically what it is based on all the evidence that I've heard, all the testimony that I've considered, this is what I think should happen in the case. Again, it's kind of their recommendation for what they think should happen in the case. They basically will do about one of three things. They can say, state, we think you carried your burden, and the penalty and or sanction that you have offered is appropriate, and that's what we're going to recommend. They can say, state, we think you carried your burden, but the penalty and or sanction is a little high, so we're going to reduce it a little bit. Or they can say, state, we don't think you carried your burden at all, and we recommend dismissing this case. Now, that's not the final step. It goes before our commission on licensing and regulation. Tomorrow, we actually have a commission meeting, and some of these cases will be heard before that commission. The commission is a 7-member body appointed by the governor who cannot have any interest in any of the programs that we currently regulate, which seems like it's getting harder and harder with all the programs that we regulate nowadays, but they do a good job of picking those folks. We do like a 5-minute, what I call Reader's Digest version of what happened in the case, as in terms of a presentation before the commission. The other side gets that same 5 minutes. The commissioners may ask questions back and forth of us, of the other side, whatever they feel like they want to ask. It all has to be contained to what happened at that SOA hearing. It can't be anything that occurred outside of that hearing. And then ultimately, at the conclusion of those presentations, they'll vote and determine what can happen. Essentially, they'll either vote to adopt the PFD. They may adopt to the PFD but modify it in some way, or they may adopt to reject or vote to reject the PFD and supplant a different ruling. So depending on the situation. So that's kind of how those orders kind of get handled. Other types of orders that we have cease and desist power. Again, we typically use these in our unlicensed cases, but we also use them in some massage cases. We have had to use it in the past in this program because there were some unlicensed builders out there that we were trying to get to stop doing what they were doing. We do also have emergency order power. That's a special order power that is granted to our executive director to shut down unsafe equipment facilities or to revoke licenses. We have used that in the context. And then again, injunctive relief, we have to go through the Attorney General's office to get into a district court to get this. But typically the way that we use this is there may be a situation where there is typically an unlicensed person or an unlicensed company that is continuing operations that we've already gotten an order against, and they just continue, and we keep seeing cases. So we'll go to the Attorney General's office, ask for representation, and we'll go into a district court to get injunctive relief to prevent them from continuing to do the thing. And if we get that injunction and that party or that company continues to do that deed or that activity, the Attorney General can seek additional monetary penalties or criminal contempt, where we can actually seek to try to get somebody thrown in jail for that. We don't use it very often. We just use it kind of in the cases that are very egregious, or in the event that we definitely see consumer harm come about. So we want to make sure that we use that very judiciously. But that is what I have. So does anybody have any questions of that process for me?
Thank you, Mr. Medlock. So I think we're going to switch over to the poll anywhere to see if there are questions. While that's being done, Mr. Medlock, I do have a question. If you could
Yes,
give
sir.
us some historical context on our department, IHB, these enforcement actions that you're talking about. I do remember the cease and desist, but aside from that, have there been what's been the volume of enforcement actions on IHB participants, things like that, and based on your knowledge?
Well, the great thing is a few years ago we had a sunset review, and one of the things that they asked us to do was to put all of our complaint statistics online. If you go to our webpage under the complaints and enforcement section, you will see a complaint statistics page, and you can actually see all of the IHB statistics that we have from starting from fiscal year 2020 all the way through 2025. We just completed those. Just to kind of give you some highlights from 2025, we received 18 complaints. And a key kind of, we use them interchangeably because of some reporting things, but a complaint coming in is somebody filing a complaint with the department. We, in the prosecutor world, deal with cases because sometimes, like I said, in that intake section, those complaints just don't merit us moving it forward because for whatever reason, some jurisdictional issues, maybe it's the wrong agency. So just because we get a complaint doesn't necessarily mean it's gonna get resolved by a prosecutor. So we received 18 complaints in fiscal year 25, and they were consumer complaints, but we didn't open any of them. Now, in terms of just other years, 2024, we received 15 complaints. One was a departmental complaint, 14 were from the consumer. We opened 4 of those cases. So as you can see, it's not a high volume of cases that we are receiving, or at least in the last couple of fiscal years. But again, all that is on our website. Like I said, from fiscal year 2020 all the way through this last fiscal year. In our fiscal year, just for reference, is September 1 through August 31st. So we're now technically in fiscal year 26 for us.
Gotcha. And just for the council's perspective, I mean, compared to, you mentioned massage or cosmetology, I mean, are we on the high end from a percentage standpoint, low end? Like, how do we compare with the other departments?
Very low end. So if you, the one thing that we do with these statistics is we put your program up against TDLR as a whole. So you'll see all the complaints that come in. So just as an example, fiscal year 25, there were 924 licensees for the program. Again, over 1 million for the entire agency that we regulate. We received 18 complaints for IHB, over 130,000 for the agency as a whole. The vast majority of that is criminal history. 118,000 of that was criminal history referrals. And again, consumer complaints we received for the agency, 12,216 were 18 were for IHB. So 18 to 12,000. That was kind of what the grouping was.
Fantastic. Okay, well that's encouraging to hear that we have a relatively clean record as a department.
Yes, absolutely.
All right. Well, it looks like we've got the poll anywhere up. Questions, please submit those. Just telling us to hang tight. While people are putting their thoughts together, one question for Ms. Melder and Ms. Cooper. We talk a lot about how we're going away from the 5 deviations and we're going to go straight to enforcement. Can you walk us through what that process would look like now if someone did have a plan review and they were audited, and then if it had deviations to it, would that get kicked over to Mr. Melder's department? How would all that work? If you can walk us through that process.
Absolutely. That has not been established yet. That will be a conversation between us, exec, and the council.
Okay.
And so we have not determined what that will look like. But ultimately, once it is decided which cases will be going over to enforcement, we would determine that the violation had occurred, gather all the evidence that we have, write up the report, send it on to the enforcement division, and then we would be out of it unless the enforcement division asked us any questions or to go and testify on as to the specifics of the code, et cetera. So that's how that would go. But we do not know yet what would be considered a direct to enforcement violation. and what wouldn't be. So
Gotcha.
that's a conversation that needs to be had between enforcement, a lot of different people. But it is it's in process.
It's in front, the
Yeah.
process is in process.
Yeah, the process is in
Yeah.
process, exactly.
And might I suggest that we have when we have our council meeting next, that we establish a process work group, so that we don't have to get the entire council involved in that unless they want to.
We typically don't include the entire council in processes, but it's something that we can discuss.
Okay. And I think industry would be, thoughtful about this is if a plan is found to have some major deviations, got kicked over to enforcement, it sounds like it's quite the process to go through Mr. Melder's department. Like, what happens to the project at that time? Does it just put on ice and just can't move forward, or how does that work?
And I will let Mr. Medlock.
Oh, sorry, Medlock,
No, that's
sorry.
okay. I respond to that question of what happens, unless you would rather I answer.
So Mr. Medlock, yeah,
Yeah,
You
in
finish your
terms of
question.
it, yeah, so it kind of depends on, like I said, the vast majority of our complaints, like I said, are consumer complaints. So it's kind of after the process is, and literally in this case, usually the building has been put wherever it was need to be and completed. So that's usually when we're seeing it. In this whole plan review kind of situation, would it be put on hold? It might be. Like I said, it's a to be determined kind of process yet. So we'll have to kind of see it as it develops. And I don't know if Charlotte wants to add anything.
I do actually, and I completely agree with John that it's possible that it will be put on hold depending on the life safety issues, but most likely it won't, because it will also be an audit and after the fact. And so it probably will not be stopping anything for this process to go forward. But it's possible.
Okay. So from an insignia and seal standpoint, those would still be issued to the building?
If it is compliant and, because as far as I understand it from the code, we have to sign off on it
Right.
as a signer, and we're not gonna sign off on anything that's not accurate. So it's possible that would be stopped, but not because of the enforcement action.
And then would the enforcement action be taken on the manufacturer, or would it be taken on the design review agency at that point?
Or the third-party inspector,
Or the third party
depending
inspector?
on who's responsible for whatever the violation is that we have determined.
Gotcha. Council, it sounds like we got our work cut up for us. All right, other questions, comments? We have a hand raised. I think is that Bob? Bob, go ahead and unmute and ask your question.
Yes, yeah, thank you. I'm doing it this way because I can't figure out how to type something. That's okay. Now, I just had a question about, it's kind of following up the most recent discussion on how the two aspects of the program are going to relate now. If TDLR does an audit of a plan that's been submitted and approved by a DRA, are they going to send a report to the DRA to review and respond to, or are they just going to, if they think there's a code violation, they're just going to send a notice to the enforcement group?
So to answer that question, we are going to work with everybody that we can because we do want compliance. However, the process itself has not been set up. So I do not know if we are going to send a report back. Our sending reports back didn't seem to go very well with the industry the last time we did it, which has led to the summit to begin with. So I'm not sure that's the process we will choose. It might just be directly to enforcement, but again, that conversation still has to be had.
Well, I mean, I would strongly encourage you to have interaction with the DRAs, because sometimes there's information there that the reviewer might not see. Sometimes two different professionals have different viewpoints about the same code section and how it's interpreted. So professional discussions happen all the time. So to not have that and just have an auditor see what they consider to be a potential code violation, send it right to an attorney for an enforcement doesn't really make good sense, to be quite honest about it.
I absolutely appreciate your comment, and we will include that when we're determining what the procedure will be.
Thank you.
Thank you, Bob. Great comment. Other comments, typed or spoken?
He's on mute.
Looks like Bob.
Bob, did you have additional comments on that? Oh, Bob Roleski. Bob, I think you were on mute. You see Bob Roleski's on mute. Oh, there he is. Hey,
Hi.
Bob. Yeah, go ahead.
No, no, the only thing I'm concerned with is that when we do a review of a document and then submit it to the department, it might stay there for a little bit until they review it. By that time, that unit's already on site. People may be living in it, might be an apartment building or whatever. So how are you gonna handle this? How do you handle that with the TDLR staff? You know, if they have a question that maybe there's a violation or discrepancy with that plan review. And right now, it doesn't seem like you have anything in writing right now how this process is going to unfold here. And I don't think it's going to. I don't know if you guys are going to get that up and running by February 1st.
So to answer your question, we are hoping, sincerely hoping, that everybody follows the statute and rules on the front end, so that when we get to that point, we don't have to stop the process, recall the building, send them to enforcement, or do any of those actions. We are relying on the licensed DRAs, our third-party inspectors, and the manufacturers to do everything that they need to do that we have gone over in the past and that we have on our mind, so that doesn't come to that. Once something like that does occur, we will have to determine what that process is going to be. But how do we handle the situation? It's really, please get it right on the front end.
So
No,
if I can add,
and
Bob,
you're absolutely right. And we're going to try everything as a third-party agency to do that. And that's what we have been doing from the beginning here. All of a sudden now it seems like there's a change in how you guys are running the department on that. So we need some boundaries here. And we're going to be working with the TDR staff to work out some of the discrepancies on this. That's what we need to know, because the interpretations we're getting, prior to this have not been very good, on that. I know I'm putting myself out there as a third party agency, but we're just going back and forth on different interpretations of the code and of the regulations. And it's very sad. This is not the way the program was meant to run.
If there is a difference of interpretation, that will be a conversation with staff. And it will be, again, process isn't in place yet, but I'd like to see that come to me. I will review it, and then I can have a discussion with our general counsel's office, enforcement, executive, or anybody else that we need to discuss it with. And then maybe even take it to the council if we need to determine what the ultimate interpretation needs to be. But
Great.
please
Let me have your email address.
Yeah, please understand that none of this means that we will stop communication. We will absolutely continue working with everyone and answering questions and giving advice, etc. We just are trying to be responsive to the industry and not hold up the process.
thank you, Bob. Those are very
Thank you
candid
for that.
comments. Appreciate you putting yourself out there on that. If I can make a suggestion, I'm not sure who Bob Johnson's with, Bob. I know who you're with. Being that this is a summit and we're trying to get just feedback, comments, and then this is very different than a council meeting where public comments are limited to 3 minutes. The question on how will the process work is being thrown out there. But I would ask the people who are participating, especially the third parties that are on the line, instead of how will the process work, how would you suggest the process work in this summit, where we can just kind of throw some ideas out so that staff can start chewing on that as far as what you think would be a best practice? How would you fix the process going forward? And maybe we can take some notes and kind of hear what the third parties have to say about that. and then incorporate that into our thinking for the future council meetings. So if you guys want to take a second to think about that, how would the process work in your opinion? And then we'll take good notes on this end and go from there. And I think I've worked with enough third parties to know you guys have a lot of really good opinions.
And if you want to type it and put it into poll everywhere, we can't misinterpret it or mishear it.
That's a good point.
And
And it'll be
we-
anonymous.
And it's anonymous, and we keep all of that information. It's able to be downloaded into a spreadsheet. Not that you have to, but we would absolutely love to hear your comments and suggestions.
So we give everyone a minute to mull on that. But internally, if we can make a note that as we set the February meeting, Carmen, that this is definitely on the agenda, process, I think is probably the best way to describe it. Just so we can talk about it in that meeting, because it seems like that's the big question that everyone has is how will the process work? And maybe we can get that going. But in the interim, how will the process work now that we've taken the training wheels off, right? How do we make sure that between now and when an actual formal process is established, we don't wreck the bike?
Well, the formal process is just to determine when it's going to be referred to enforcement.
Gotcha.
So I don't think the bike can be wrecked.
Okay, good.
Because everything will still be coming in, inspectors will still be going out, and processes will continue. So I hope that is the issue. How would you recommend the process work? That is the question we are asking you.
Right.
The question that was just typed. The process with our other programs is when conducting an audit, we look at a document that has been created between the divisions. And so as John was mentioning, it's a list of, if this violation occurs, this will come to enforcement. If this violation occurs and it's not that serious, it's not going to come to enforcement. We will look at that list, determine if it needs to be referred or not. And the process that we're talking about is, who are we even going to audit? Which process are we going to look at? And then once we determine that, how do we determine what is high risk? And, what random software are we going to use? And are we going to put, as the comment suggested, a step one, call the manufacturer, call the DRA, call the third-party inspector before we even refer them to enforcement? So as far as the process goes, these are the questions that we're asking and what will be included once we come up with what everybody agrees for the process to be.
Thank you for that.
Charlotte, for the record, I've added that question.
Oh.
Documented what the question was.
Got it. I was like, that is the question we're asking. But we actually really would love suggestions.
I think from a suggestion standpoint, they can
Yes.
email those in.
They absolutely, yes, I've said absolutely 12 to 15 times a minute, but yes, please mail those in.
Yes.
Tech info, I believe is it tech info at what?
At TDLR.Texas.
Tech info. You
Can
can
you
email those.
copy the some of the council members on that too, Ms. Cooper? When those do come in, just so we're aware of industry feedback on how they think the process should work.
Okay. Is that gonna be an issue with sharing emails?
Don't share emails.
Just
You'll have to do it, yes. Tam, while we're sitting here, will you add that one suggestion that did come in of contacting the supposed violator before we refer to enforcement?
I can get that right.
Okay. Oh, okay. Oh, that's fine. All right.
And I just for historical note, I want to underscore one of the things, I think it was Bob or Bob said this, where it's a lot of times these building plan reviews are a conversation, right? It's not just cut and dry like, oh, it has to be this way, or it has to be that way. And somehow we've got to get that feedback loop in place so that things don't become just black and white, that there's some way to talk about them.
And actually, I would like to jump in
Yeah.
and say that process changed as well. I
Mhm.
am the director over the entire compliance division. We have 40 some odd programs and the experts themselves are housed in this division. And so we have section managers, we have supervisors, etc. But for the IHB program, because of the issues that we're having, all of those sorts of decisions are coming through me. So I have inserted myself in the process.
Awesome.
Yeah, I think, by the way, the tech info, we have several tech infos for a lot of our programs. I think it might be tech info.
Is IHB taken?
Yeah. Not just tech info, it's IHB tech info. We're gonna get the exact address,
Yes.
and somebody's gonna type it into the poll everywhere so everybody can see it. For when you send in those email addresses, because tech info by itself will go to a different program. Okay,
Looks like we've got a big comment here.
it does.
What do we got here?
Okay, so we've got the one that was already stated, and I'm gonna read this. If you'll scroll as I'm reading, that'd be great. As the Texas Industrialized Housing and Building IHB program continues to evolve, we believe there may be value in exploring greater coordination with existing interstate frameworks that were specifically created to promote consistency and reciprocity in industrialized construction programs. One potential option for the consideration is the Interstate Industrialized Building Commission. The IIBC was established to facilitate uniform interpretation, reciprocal acceptance, and best practice alignment among state industrialized building programs, while fully respecting each state's statutory authority and enforcement role. Leveraging the IIBC as an advisory or coordination resource rather than as a regulatory authority could help promote consistent interpretations, reduce friction between regulators and third-party agencies, and support predictability for manufacturers operating across multiple jurisdictions, all while preserving TDLR's oversight and enforcement responsibilities under Chapter 1202 and 16 TAC Chapter 70. We offer this solely as a constructive suggestion and would welcome the opportunity to discuss whether interstate coordination tools like the IIBC could complement TDLR's existing program structure as the program matures. Thank you very much for that suggestion, and it will be taken into consideration.
Yeah, so we've got that on the table. We've got the, what is it, that ICC standard 1200 and 1205 that we talked about in the last council meeting as
That's
well.
correct, yes.
And so those will come up in our rules work group, right? And we'll have a chance to discuss that. But yeah, definitely the IBC. Thank you for whoever put that comment in. All right, do we have the email address if people have suggestions on how the process should work up in the poll? Yes, we have.
Are you putting it in there?
I am.
I was waiting for,
Get it.
We have a question from a live audience member. Is that okay?
absolutely.
Okay.
So I wanted to know if there is any training provided for the design review agencies or the third-party inspections.
Yes. Chrissy,
Yes.
she would like to know what training is provided for the design review agencies and the
Third-party inspections.
third-party inspectors.
We do not provide any.
We do provide training. The initial run through of the red something,
That's for the manufacturer.
oh, manufacturers, okay.
Right.
And then online, do we have any,
Not that I'm aware of.
I
We
misspoke.
provide,
I'm
we
sorry.
provide procedures,
Okay, but not
Okay.
actual training.
not actual training.
Providing actual training is something that is coming soon.
Yeah, that would be really good, I think. for
Completely
the
agree with you.
Other ones, yeah.
Yeah,
I agree with you, and certainly as the processes change, I think that it would be a wise move to have maybe another summit where we could make this open to everyone. Explaining processes.
having videos online, we're doing that for a lot of our programs.
Yeah.
We currently, as we stated at the beginning, have one staff member dedicated to this program, but we are hiring. We have multiple openings and we hope to have a very robust team soon. And once we have that robust team, that will be a focus.
Amazing, thank
So,
you.
absolutely. I thought it already happened. So good to know.
And you know, Charlotte, that is a great comment you just made. If this forum is a nice one for this group, we can certainly do more of these.
Okay, so the email address is now on the chat log. It's techinfo@tdlr.texas.gov.
No, it's not.
Okay,
Hold on,
It's
we're gonna
not.
correct
It's
that.
IHB Tech.
yeah,
I'm sorry,
IHB Tech.
I used to work in architectural
I
barriers.
know,
Yes.
I know.
So the address that's on there, Tamara, do you have any ability to delete that? Because that's not the address they need to send it to.
I'm sorry. I don't ever email myself.
I know, but we said it 3 times. That is not it. It is,
I sent it to you, Tamla. Should be in your chat.
Thank you, Carmen.
No problem.
so she's trying to figure out a way to delete that.
I think I can delete it.
You have to delete it, whoever entered it.
Oh, we'll try.
Thank you.
I clear responses, I clear everything, so.
There we go,
It's
it's gone.
gone.
Thank you very much. I'm so sorry. The
I
correct one will be
apologize.
entered very
I
soon.
think Carmen, okay. I got a lot going on over here.
All right. Well, I think that's all the comments on this section. Mr. Medlock, thank you for your presentation. Appreciate that. I guess we're on to closing remarks. Mr. Bruno.
I don't have any other than to say, let's keep doing this. If there are other topics or we need to continue this topic, I really love these forums where we can all get together and hear from the community and share our thoughts. So let's keep it up.
Fantastic. And as for me, you know, I think I said in the beginning that I was optimistic to see a lot of the actions that the department is taking. Hopefully, after hearing what you've heard today, council members as well as the general public who've attended, you're optimistic as well that, yeah, the program is very open-minded. It's trying to be very transparent, and we're gonna work together on figuring out these processes to make it as efficient as possible while still protecting our citizens in Texas. So with that, if there's no further business, the summit is now adjourned. Thank you for your contributions and attendance, and the time is 10:58.
So we're gonna say.
We did get the IHB Tech up there.
Oh, yeah.